In this video, I will explain 3 legal traps that catch U.S. companies off guard when they do business in Latin America. These are international commercial risks that hit Miami-based exporters especially hard. And by the end of this video, you will know how to spot these traps before they cost you real money. You'll understand why your standard U.S. contract might be worthless south of the border, and you'll have a clear picture of what to do differently. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I spent my career helping U.S. companies navigate the legal landscape of Latin America, so I've seen every version of these mistakes. Let me walk you through them so you don't have to learn the hard way. Imagine a Miami company that ships a $400,000 order of industrial equipment to a distributor in Colombia. The contract looks solid. Payment terms are clear. Then 3 months later, they still haven't been paid. They call a lawyer in Bogota and hear the worst words possible. Your contract isn't enforceable here. That's not a hypothetical. That happens, and it happens all the time. That happens more often than you'd think. Situations like this don't happen randomly. They follow a pattern, and the first trap is usually hiding in plain sight. And here's the first trap, the jurisdiction clause. Almost every U.S. company I work with puts a jurisdiction clause in their contract. It usually says something like any dispute shall be resolved in the courts of Miami-Dade County, Florida. It sounds protective, right? It feels like you're locking in home court advantage. The problem is that clause means almost nothing in most of Latin America, and let me explain why. When you win a judgment in a Florida court, you'll still need to enforce it in the country where your buyer's assets are. That means you take your Florida judgment to a court in Mexico or Brazil or Argentina, and that court gets to decide whether it will honor your judgment. Many Latin American countries do not automatically recognize U.S. court judgments. Brazil has its own process, and Mexico has a completely separate framework. In some countries, the local court will review the entire case from scratch. Your Florida judgment becomes a suggestion and not an order. So what should you do instead? The answer from most Miami exporters is international arbitration. Arbitral awards issued under conventions like the New York Convention are enforceable in over 170 countries. That includes virtually every major economy in Latin America. An arbitration clause gives you teeth that a jurisdiction clause simply cannot. Think of it this way. A jurisdiction clause is a lock on a door that only exists in your house. An arbitration clause is a lock that works on every door in the neighborhood. Now, the second trap is one that surprises people because it seems so basic. U.S. companies assume that if a deal is legal in Florida, it's legal everywhere, and that assumption can destroy a transaction. Latin American countries have aggressive consumer protection laws, and many of them go far beyond what we have here in the United States. In Brazil, they have a law that gives buyers rights that cannot be waived by contract. It doesn't matter what your agreement says. If the law says that the buyer has a right to return the product within a certain window, that right exists. Your contract cannot override it. Colombia has a similar protection. So does Chile. Argentina has a history of applying consumer protection statutes even in business-to-business transactions under certain conditions. That catches U.S. exporters completely off guard. Now here's where it gets worse. Some of these countries have mandatory warranty periods that exceed what you planned for. Others require specific product labeling or disclosures that your U.S. packaging doesn't include. A failure to comply doesn't just mean a fine, it can mean your goods get seized at customs. It can mean your buyer has a legal right to cancel the deal and demand a full refund. Now before I get to the third trap, which is the one I see destroy the most value, I want to ask you something. If you're finding this useful, take a second and hit that like button. It helps this video reach other business owners who need this information. And if you're not subscribed, go ahead and subscribe so you don't miss future videos where I break down the legal risks that affects your bottom line. All right, let's keep going. Now this is the one that keeps me busy. Trap number 3 is currency controls and payment reparation risk. This is the one that leaves you holding an invoice that the buyer cannot legally pay. Several Latin American countries restrict how their citizens and businesses move money out of the country. Argentina is the most well-known example. They have a system of capital controls that limits how many US dollars an Argentine company can purchase to pay a foreign supplier. Your buyer might want to pay you. They might have the pesos sitting in your bank account, but the central bank won't let them convert those pesos to dollars to wire you this payment. This isn't a credit risk issue. This is a sovereign risk issue. Your buyer is not defaulting. Their government is standing between you and your money. Venezuela has had extreme versions of this for years, but even countries with more stable economies can impose temporary currency restrictions during economic downturns. Brazil has done it in the past, and Ecuador has had restrictions tied to its dollarized economy. All right, so how do you protect yourself? First, your contract needs to address currency risk explicitly. Specify the currency of payment. Specify who bears the risk if the exchange rate moves. Second, consider requiring payment through an offshore account or a letter of credit from an international bank. And third, build in contract language that addresses what happens if currency controls prevent payment. Without that language, you're left arguing over force majeure, and that's a fight you don't want to have in a foreign court. I've seen deals where the U.S. company did everything right on the product side, great quality, on-time delivery, and perfect documentation, and they still didn't get paid for 18 months because of currency controls. And that is a cash flow problem that can sink a small or mid-sized exporter. So let me bring this all together. If you're a U.S. company doing business in Latin America, especially if you're based right here in Miami, you need to watch out for three things. First, your jurisdiction clause probably won't protect you. Use international arbitration instead. Second, local consumer and commercial regulations can override your contract terms. Know the rules before you ship. And third, currency controls can prevent your buyer from paying you even when they want to. So structure your payment terms to account for that reality. These aren't just wild scenarios. These are everyday risks for exporters working across borders. The good news is that every one of them is preventable with the right legal structure in place from the start. Now, if this video helped you see your international deals a little more clearly, hit that button and subscribe to this channel. I put out videos like this regularly to help business owners protect themselves when the stakes are high and the law crosses borders. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.